Hello, my name is Kwenda Esnat. I'm in 3-2 Class H Vegetable Law School, and my facilitator is Ms. Kosana Makosa on Jurisprudence. So I'm going to talk about critical legal studies movement. So it is a branch of jurisprudence that emerged in the mid-1970s in United States of America and also in United Kingdom almost at the same time. However, it has been largely a US movement that was influenced to a greater extent by European philosophers such as 19th century German social theorists Karl Marx, Friedrich Engels, and Max Weber, among others. So what is it all about? It is all about the fact that most of the work of law is seen in the court, that is legal realism. It is what the judges do on how they come up with certain judgments, and this has been repudiated by the critical legal studies, legal scholars. They rejected the view that the law and the existence of law is somehow separate from the rest of the society. They argued that the law is not and can never be independent from politics, morality, economics, and philosophy, for example. The law is something that is developed through society. It exists because society exists. Hence, it is made by society, politics, economics, and incorporates things such as morality, ethics, and philosophy. So, critical legal studies is a movement that challenges and seeks to overturn accepted norms and standards in legal theory and practice. It seeks to fundamentally transform jurisprudence, exposing it not as a rational system that accumulates wisdom, but as an ideology that supports and enables unjust political institutions. Critical legal studies academics seeks to debunk the law's pretensions to determinacy, neutrality, and objectivity. In critical legal studies scholarship, law is the two institutions used to maintain their power and rule over unequal realities. As an open left-wing political movement, critical legal studies seeks to subvert the philosophical and political authority of what it sees as an unjust social system. So I'm going to talk about the main themes of the critical legal studies. These include that law is politics. So scholars of the critical legal studies movement dispute the idea that the powers of judges and other government officials can or should be limited by legal sources such as the Constitution, statutes, and precedents. It is characterized by refusal to believe that legal argumentation can or should be an enterprise distinct from political argumentation. It is also characterized by a rejection of legal rights as a desirable or even possible means of protecting individuals from governmental power. Scholars like Mark Tushnet, James Boyle, Roberto Anga, and Duncan Kennedy argue that political value judgments infiltrate the law at every turn. The most important proposition of critical legal study is that law is politics. Legal reasoning is no different than political reasoning. Like political disputes, legal disputes are resolved through a vague combination of coercion and reasoning. Anyway, this is not pure reasoning. This is the first theme of the critique, that all law is developed in order to serve the interests of the political group in power during that time. No matter how the law has been framed, it really is interpreted to propel and push for the interests of the politically connected. So a good illustration is the case of Chamisa versus Mnangagwa and others. The appellant was the presidential candidate of the MDC alliance, which alleged ZEC's presidential results, in which Mnangagwa had been declared the winner, citing election irregularities and rigging by ZANU-PF. It was held by the Constitutional Court. The applicant failed to produce V11 to support his claim, hence court challenge dismissed. This judgment shows that indeed the law is there to protect the interests of the political elite. Then to move on, another theme is law is there to serve the interest of the wealthy. This is another theme of the case, in which they argued that the purpose of the law is to serve the interest of the wealthy people whilst sidelining the poor. Critical legal studies finds that the world use the law as a tool of oppression to maintain their place in the count. Men in the critical legal studies movement want to overturn the hierarchical structures of modern society, and they use the law as a tool to do so. Thus, although the rules are the same, they are applied in a subjective manner that protects the interests of the rich, hence a way of maintaining a gap in inequality in the society. Another illustration of a case is Zambezi Zimbabwe versus N. Arababa and another. So in this case, the law affirmed was that the US dollar balances were on a one-to-one equivalent with the Zimbabwean dollar. This law was pro-rich whilst it sidelined the poor and eroded the value of their savings, as hard-earned US dollar were converted into Zimbabwean dollars, which had a low value. Moving on, we are going to discuss that the law is also contradictory. Here the critics argue that the law advocates rigid procedures to be applied, for example, in case law or judicial precedent, whilst at the same time the law advocates for flexibility in the application of the law. So another theme is the autonomy of judges in legal interpretation. The formalistic view is that judges are autonomous when interpreting the law. They are not affected by society, judges, or social convictions. However, the critics argue that judges are constrained by their background, political, and social convictions. According to critical legal study, this lack of determinacy shakes the very foundations of liberal, reformist notions of efficiency and justice. As a result, they concluded that to a larger extent, judges make the law which is inconsistent with liberal conceptions of legitimacy, sources of lawmaking authority. For on this view, democratic ideals imply that lawmaking must be left to legislatures who, unlike appointed judges, are accountable to their electorates. As such, critical legal studies insist that the subjective decision-making behind the so-called objective formal rule of law must be exposed in order to undermine the generally conservative decisions of judges, which are clouded by notions of impartiality and fairness. Moving on to another theme, all imaginable legal questions are indeterminable. One aspect of critical legal theory which is important is the concept of indeterminacy. Far from being determinate, the law is instead uncertain, ambiguous, and unstable. The law is neither neutral nor objective. The critical legal movement challenges the assumption that the law is a system capable of solving all possible problems. This is known as the indeterminacy principle. So for the critical legal studies movement, if law is indeterminate, legal scholarship which defines what law is becomes pure propaganda and an offshoot of political debate. In essence, the legal indeterminacy of the critical legal studies view asserts that the law does not necessarily produce a particular outcome. So any developed legal system allows lawyers and judges to explore principles and rules within and outside the system. Within this system, for example, contract lawyers may rely on the dominant concept of agreement to establish rights and the subordinate concept of error and fraud to undermine rights. Yet, you sought a slightly different outcome, you might have appealed to some socio-political principle to attack the contract itself. So, in summation, the critical legal studies movement scholars generally argue that law is not separate from the rest of the society. Thus, they argue that law can never be independent from politics, morality, economics, linguistics, and philosophy. Hence, it is made by the society, it is made by the politics, it is made by the economics, and incorporates things such as morality, ethics, and philosophy. Thank you.